Hello, everybody. Glad you're here today. My name is Pastor Sean. If you're new and visiting us, thanks for joining us online right now. We've got a great presentation for all of us, and I just wanted to welcome you here and looking forward to the information that we're going to get. You know, it's funny. I was as I was out in the foyer, I was thinking to myself, if this was anything like church, everybody should show up in about 20 minutes, right? When we should normally start. So we're not going to wait. We are going to get started in about 5 minutes. We're going to give them 5 minutes, let you grab something, a coffee or some water online, and then you can join us for this wonderful presentation. Jerry is actually going to be hosting throughout the presentations. And after each presenter is done, we're going to have about 5 minutes of a Q&A. If you have any questions, I'll walk around with the microphone so that people online can hear your question. And then they'll be able to answer in a way that's going to help you. So we'll start in about 5 minutes, and looking forward to it.
So I echo Pastor Sean's good evening, everyone, and welcome to the Be Prepared seminar, a workshop with regard to planning estates and finances, with regard to prearranging funerals, with regard to accounting and senior residences. Our format, as Pastor Sean has mentioned, that we have some excellent presenters. They will speak for about 10 minutes. Then at the end of the 10 minutes, there'll be time for Q&A. Sean and I thought it was likely best to do the questions right after the presenters when it's kind of still fresh in your mind. And then at the end of the night, if there's some general questions that we're to answer, we will do that. So membership has its privileges, and belonging to the church makes you the first speaker tonight. And that's the chair of our finance committee, and certainly a brother in Christ at All Nations. And I'd ask Fred Slade to come up to present about accounting. Fred?
How's that? Does that sound okay? Yes? No? Maybe? No? Didn't sound very good at all. Is it on? Yeah, it's on. I just got to get closer. Okay, good. Oh. Yeah, that'll work good. Yeah. Okay, so, yeah, be prepared. Well, I'm not off to a very good start because I didn't prepare any remarks beforehand. So don't let that throw you off, but you know, that is actually kind of the situation most people find themselves in many instances in life, and even more so perhaps in death. Okay, so I know this isn't strictly about death, and but that's the one thing that's certain. Everybody here, everybody out there, we're all going to pass at some point in time. And for those of us that know the Lord, that's not a bad thing. That's a great thing. But it can be a very bad thing for those we leave behind if we and they, perhaps jointly with us, don't prepare. And I base that on experience. I've buried three family members in the last 4 years. My father, my mother, and on January 17th, I didn't bury my brother on January 17th, but he passed on January 17th of this year, my younger brother. And that was tough. He was 65 years old, so, you know, he'd had a good life. But my parents were in their 90s, or my dad was 2 weeks short, and my mother was 92, I think. So totally not unexpected. And, you know, there's lots of 65-year-olds that if they pass, everything's been planned or rearranged or anticipated, because, I mean, we could anticipate we're going to die when we're 10 days old. I guess probably not thinking about things like that, but, you know, when you're 20 years old, you realize we're going to die someday. Doesn't mean you have to plan for it, but it does mean you should keep that in mind. And at those days, probably the best thing to do is talk to your parents or your grandparents about things. Because the number one problem that I find, I guess the reason I'm up here, Jerry talked about accounting. There's not really a lot of accounting to do. But as an accountant, I deal with clients that pass. And it can be simple or it can be complicated. And I think that's really the whole goal. You want things to be simple. So with my parents, it was pretty simple because we had a talk probably when they were in their mid-70s about the fact that if things don't, you know, go well, something happens in the next little while, we've already prearranged our funerals. My parents, there was a group in town, I think it still exists in town, Jerry could fill us in on this, that believes in pre-planning your funerals. Now, of course, the funeral homes can help you with that. And they had done that. So when they passed, we didn't have to worry about it. But we didn't have to worry about it for the 15 years beforehand because we knew it had been taken care of. We also knew that wills and powers of attorney had been taken care of at that time because that's when we did it. Okay, in the early 90s, I was made the power of attorney for both my parents, and their wills were both drafted, and they actually never had to get changed in the last 20 years. So things went real smoothly. As my parents aged and I started taking over their finances, that's something to think about, okay? It's not just debt. There's incapacity, and there's even just, you know, maybe you're not incapacitated or your parents aren't incapacitated, but it's just better to have somebody else taking care of things. Things don't get forgotten. And maybe even more importantly, people don't get taken advantage of, right? That's a real danger with seniors. And so I remember my dad one time getting one of those Facebook internet things. I had to call the bank and tell them, if he comes in, don't let him buy a Western Union thing. Now, he was still very capable of doing many things, but he came up from a generation where you trust everybody. There was no internet scams when he grew up. He thought it was the real person, right? Anyways, things went smoothly with them. My brother, he died on January 17th. I was having a beer with him and talking about things that he was going to be doing the next day and this summer on January 16th. I got a call at 7 o'clock at night saying he was being brought to the hospital by ambulance, and he breathed his last breath at 11 o'clock that night. He never regained consciousness. It was a tough time, but it's an interesting time now because my brother never married, never made a will, and he owned 4 different properties. He owned 40 motorcycles, and he had all kinds of other things that needed taken care of. So I've been doing that for the past 3 months, and I anticipate that I'll be doing that for the next, well, I don't know, probably at least 3 or 4 months, maybe longer, maybe much longer, I don't know. There probably still would have been a lot of work with him. So, you know, we never know what's going to happen. I think, you know, as we get closer, or as our parents get closer, that's the toughest thing, is people don't talk with their parents about it, or parents don't talk to their kids about it. I mean, it's a real thing. Everybody's got their different dynamics. I'm so glad we had that conversation with my parents. And even though we never had that sort of conversation with my brother, you know, we started to realize it. At my age, I'm 67, at his age, you know, we're reading obituaries of people that are younger than us, you know, a lot more often than we used to. So one thing that I would highly recommend from an accounting point of view is to try, if you or your parents are at that age, try and maybe simplify things a little bit, consolidate things a little bit. One thing, accounting is keeping track of stuff, okay, but it's not just debits and credits and stuff like that. Put together a summary of what you have and where it is, what the passwords are, things along those lines. I can actually make available to you, to everybody, because I'll make it generic, but I've been the executive of a number of people, and a friend of mine, he just lost his wife. Probably a month and a half later, he called me and asked me if I would be his executor. And I said, okay. I said, but you need to give me a little bit of background on exactly what I have to do. He sent me this list. It's unbelievable. Everything is listed there. Car keys are here. Important papers are here. Insurance is, here's the name of my accountant. Here's the name of my investment advisor. Here's my will. Everything else. It's all done up. It'll still be work, but I'll know exactly what I need to do. The toughest time me and my sister have had with my brother's passing is trying to figure out what he would want us to do with his estate. So, I'm going to leave it there. I think, first of all, I want to be on time. And second of all, I think if there's any extra time, it's probably better spent asking questions than trying to figure out what everybody needs to know. So I'm going to wrap up right now and take some questions.
Fred's actually a minute early, so God bless you, Fred. That's the first, I think, for Fred Slate. Absolutely. So, questions. If Sean's going to be kind of the Oprah Winfrey person tonight, he has the microphone and he will get you to ask your questions. We need that one brave soul to ask the first question.
Oh, we got lots.
Oh, I got a couple.
Right on. That's good.
Oprah Winfrey, what? You get a car, and you get a car. No, all right, so we'll start right here. Did you have a question, or you just want the car?
Just a comment, actually, I was going to say, I work for the CRA, and what some people don't realize is with all the privacy laws and things that we have now, good luck trying to get things sorted out there. So it really is good to have the power of attorney. Like I talked to an elderly woman today, she's the power of attorney for her husband. Had she not had that document in place, I wouldn't have told her a thing, not one thing, and it just really makes an already difficult time much more difficult when you're dealing with the government, because with all the privacy laws that are in place now, it's very difficult to get through this kind of stuff. So, and I was fortunate, like you were, when my mom and dad passed, they had everything in order, so everything was very easy. So it really does help make it easier. So.
And it's a great point. I'm glad you brought it up because, trust me, I deal with it, and it's a little easier now. Like, we have the authorizations ahead of time, and they used to end those authorizations immediately. They're being a little more lenient now because I think it's caused so much disruption. But the same thing's going to happen at the bank, and anywhere else that you need to deal. So, yeah, it makes it much better. Probably even better with power of attorneys. The incapacity can be more difficult to deal with than death. Sometimes on death, assets can get transferred quickly or whatever, but with incapacity, sudden incapacity, you could have some real problems.
So I think that brings up a question then, is that if you're married, your spouse isn't automatically the power of attorney for you?
That's the legal question that I don't have an answer to.
Well, we've got a legal person that's going to come up too,
They're
so
gonna
that's
come up
perfect.
there, so,
Yeah, excellent. All right, another question.
We have our will done and power of attorney, all that stuff. But I think I've heard that when somebody dies, there can be extra expenses unless you do something to prevent it. I'm not sure what, but with the estate.
Oh, I think
taxes and that kind of thing?
you're probably talking about probate fees, okay? A lot of people talk about, is there death taxes or estate taxes? We have no death taxes in Canada, but what we do have is we have what's called probate fees. So when you pass, and again, your lawyer's going to help you out with this. It's generally really advisable to get a lawyer to help you with the estate, although it's not 100% necessary if you've done a real good job of setting everything up. But there's probably going to be some things they're going to help you with, and that one may be probate. You can do some other stuff so that you can avoid probating assets. In my parents' case, we had a family trust, so we didn't have to do anything. But what happens, what you're asking about is the estate is valued, and it's basically just a tax on the value of the estate at death, okay? And I think the first, and our lawyer probably helps out a lot on this, but the first certain amount, there's nothing, and then I think it's everything over 50,000 is taxed at 0.15% or something like that, or 1.5%. It can add up. If you've got $1 million estate or something, there are certain things you can do to avoid probate, anticipate, again, being prepared. But you want to check, because a lot of people make mistakes about that. They think doing it this way works, and it may not. So you want to check with your bank when it comes down to certain things. Putting things in joint names is the way to do it, but that can trigger tax problems. So if you're doing stuff like that, yeah, talk to the lawyer, talk to a tax accountant about it.
So before I move on, you used a word there that some might not know, probate. Maybe you can explain what that word is.
Well, basically, and again, I'm getting into the legal stuff here, but if you have a will, all your assets are basically, if you have an estate, all your assets are basically frozen on your death. Now, if there's joint names or if there's a trust or something like that, the other people can deal with it. But if it's just you, it's like my brother, okay, we couldn't do anything with any of his bank accounts, any of his properties, any of those motorcycles. We were the first thing we had to do was because he didn't have a will, we had to get appointed as his executors, and there's laws about that. What happens if you don't have a will? And in our case, it worked out pretty good because your siblings are the first choice if you have any. And fortunately, the three of us got along really, really, really well. But that could be a horrible nightmare if you had, somebody that died without a will and they had siblings that weren't getting along or something. It would be a total disaster. But to deal with the bank will not, if the bank account is in the deceased name only, I believe the bank will not allow anything to be done with that until the will is probated, which isn't really that difficult a thing, but it involves a fee. And you get a lawyer you can do it yourself, but I'd recommend getting
Keep
a lawyer.
going. Okay. So I'm gonna stop there. But so we do have a lawyer that's going to come speak to us too. So let your question be in the finance area right now and accounting, and then we'll also have a Q&A for that too. So who else had their hand up? I saw there was. Okay, so I'm going to go to Ian here.
Thanks, Fred. And I could ask you this personally, but I think for the benefit of everyone, you mentioned something. I think what you were saying is in order to organize that document where everything is there a software program? Was that what you were referring to?
No, actually, you can just Google, how to be prepared for when I die or something, and you'll see people make a list. And in fact, lots of financial institutions put them out. I don't know, Jerry, the stuff that you hand out to people probably has that. If you pre-arrange your funeral, you've probably got some kind of, where's my life insurance policies? Where's this? Where's that? Who do I have ongoing stuff? I mean, even, things like canceling magazine subscriptions, stuff like that. I mean, there's so many little details that you have to take care of. If you know what they all are. I'm just talking about a friend of mine. I was just so impressed with this list. I mean, he tells me where to find the passcodes for all his different accounts, right? Here's where all the different accounts are. Here's where the passcodes are. So, it's a very thorough list. So I think I'm getting the hook here. So,
Friends,
if anybody has a question afterwards, come and see me. I'm going to stick around. If anybody has a question out there in Wonder World that want to get a hold of me, 674-6494 is my office. I won't charge you for asking your questions. I will not probably act for you, okay, for two reasons. Really for one reason. That's not what this is about. I'm not trying to get business. But secondly, I'm preparing for, I have no plans to retire. I have no desire to retire. But I know, like everybody else, one day I'm going to retire, whether it's on my terms or not. And I do know that I'm 67 and a half years closer to that date than the day I was born. So I'm trying to simplify things.
ladies and gentlemen, Fred Slade. Thank you, Fred. Well done. Bit of an aside. So there's that issue with the banks, which they don't advertise. All banks, credit unions, case populaires, any accounts under $25,000. If you bring the will, a death certificate, the bank manager has the authority to waive the probate requirements. So people that have small bank accounts, they can obviously don't have to go through the formal process. Obviously, through Fred's questions, we know our next speaker will get lots of questions. He's the lawyer. And again, perhaps not a member of our church, but certainly a friend of our church. Our elders are in the process of actually doing some incorporation, which is kind of legal jumble bumble to make sure that we kind of own things properly. His dad is Mac St. Clair. I asked Mac, how much are you going to charge the church? And Mac said, what I've charged them for the last 50 years. I said, what's that, Mac? He said, absolutely nothing. So you can't get a better deal for All Nations Church than St. Clair and St. Clair. And I'd like you to welcome Ian St. Clair to talk about the legal aspects of being prepared. Welcome, Ian.
Thank you for the introduction. Can everyone hear me?
Yep.
Okay. My name's Ian Sinclair. I'm a lawyer in Sudbury with the firm of Sinclair and Sinclair. We do, among our practices, we do wills and estates. We prepare wills and powers of attorney, and we also help families with estates after a person has passed away. So I will talk at first about the preparation of wills and powers of attorney, which is what you can do while you're alive. And then I noticed there were some questions about probate and how to relate to administration of estates once a person passes. So the second part of my talk, I'll try to answer some of the questions that I think people may have been wondering, and sort of flows from what Fred was asked. The first thing you have to do when you're trying to get organized is you should have a will. And the will is the document where you outline what you want, how you want all of your assets to be handled and to be transferred to whoever it is on your passing. So the first thing you have to do when you're doing a will is you have to name who the executor is going to be of your will. And the usual easy thing with trying to name an executor is that if you're a spouse and you're married, you would normally name the spouse and vice versa. If you're not married, or if your spouse has passed on, then you have to still name an executor. And the question you have to ask is, who are you comfortable managing your estate? So normal candidates or people you would consider would be family members. If your children are adults and you're confident and comfortable that they can manage things. If your children are young or younger, you might consider naming, your sibling, family friends, something like that. So it's important to pick who you want, but at the end of the day, it's who you're comfortable with. And you want to give some consideration also to the age of the person. You normally would not, if you were in your 50s or 60s, you normally wouldn't name someone who was in their 90s to be an executor of your estate, because the odds are that the person in their 50s or 60s would live longer than the person in their 90s. But the other thing that's important when you're naming the executors, you also have to name an alternate or alternates. So while you will name the main person who you want to be the executor, if that person is unable to be the executor of your estate, say it was you named your spouse and you both passed away in a tragic accident, prudent planning is that you should name an alternate executor. And again, it sort of goes back to who are you comfortable with naming as the alternate executor. Again, it's the same thing that you look at. Is it are your kids adults? Are you comfortable that they can do it? If your kids are too young, like either they're still in school or they're under the age of 18, then you would consider naming family friends, or a relative like your brother, your sister, brother-in-law, sister-in-law, things like that. It really boils down to who are you comfortable and confident can manage it, because there is a responsibility that an executor has, and that's to manage the estate properly. So if you have some concerns that some of the people that might not be responsible, they're not good at managing money or being organized, or if you're concerned that they have health issues of their own, then those people would not be, good candidates. You want to pick people that you think are responsible and can do it. After naming the executor, the next thing that you have to consider is who are you leaving everything to under your will. And sometimes this is a decision that some people can make very quickly, or it's very obvious and straightforward to them. But other times, family dynamics are such that people have a harder time trying to figure this out. Now, if you are married, normally you would leave everything to your spouse, and then under the spouse's will, they would leave everything to you. But if you're not married, or you're a widow or widower, then the question is, who do you want to leave things to? And if you have children, the normal thought is, well, I'll just leave it to the kids on an equal basis. That's what a lot of people do. Other people will want to maybe leave some bequests or donations to charities or to specific family members. Again, it's all up to you. It's your estate. It's how you want it to go. But you have to consider who you want to leave things to, especially on the last of you and your spouse to pass away. And sometimes you might have some family heirlooms that you may want to go to a specific person. You may want to leave some charitable donations to certain charities, or you may just decide you want to leave some funds to a nephew or niece or various family members, or you might just want to leave it all split evenly amongst your children. It's up to you, but those are the questions you have to be thinking about. The next thing that always comes up is the age of inheritance. So if you're a younger person like myself and your kids are under the age of 18, you cannot, under a will, you can't give assets to a minor. So you have to pick an age of inheritance. At law, you can't pass on assets of an estate to someone until they're the age of majority, which is still the age of 18. But the concern in today's world is 18 might be a little bit too young. And so the general thought is have the age of inheritance maybe once the kids or the young adults have finished at least one post-secondary program, and they may have been in the working world for a few years, with the idea that they've become more mature. So most people sometimes consider ages 25 or 30 as the age of inheritance. Again, it's up to you. Some people have left it at 18 and they just decided they're adults, we're leaving it, but other people just, the way the world is today, they feel better if the kids have maybe gone through some post-secondary and they've started working for a few years. It's up to you. It can't be anything less than 18. So that's an issue, and it's not just if your kids are under the age of 18, but if you're a grandparent and you're looking to leave some money under your will either to your grandchildren, or if you're worried that under your will you were going to leave things to your kids equally, but what happens if one of your children passes away? Do you want their share to go to their own children, your grandchildren? Then you have to think about age of inheritance. So that's another thing that comes up regularly. And then following on the issue of the children is you have to decide if you have children that are under the age of 18, you need to think of legal guardians for your children. So that would be the people that if both you and your spouse have passed away and the kids have lost their parents, who do you want to name as the guardians of the children? And I've seen some parents have a hard time figuring that out. Sometimes it's quite obvious and it's easy. They'll just name, the aunt and uncle, or the brother and sister-in-law as the guardians of the children. But other times, due to the family dynamics, or you don't think, your brother or your sister's the right fit, you'll sometimes have a hard time figuring out who that person's supposed to be. But that's another thing you have to consider if your children are under the age of 18. You have to think about who the guardians of the children are. So those are sort of the basic points that I can give to you tonight on which the main points for a will. The other thing which I think came up briefly earlier was powers of attorney. So whereas the will covers the situation where the person has passed away, the powers of attorney are for the person while they're alive, but they've become incapacitated. And when I say incapacitated, I mean they're no longer able to manage their affairs, either because they've had a debilitating stroke, person may have been in an accident and they're unconscious, or they're just not able to manage their affairs. Or sadly, as people get older, they sometimes develop dementia or Alzheimer's or some illness where they're no longer able to manage their affairs, but they're still alive. So the two types of powers of attorney, one is the power of attorney for personal care, and that covers the situation where you're alive but you're incapacitated, and you're naming the power of attorney who will look after your personal care. So it might also be known as, some people call it the health care power of attorney. So that power of attorney gives the attorney the right to deal with the doctors, give instructions to the doctors on medical procedures that might have to be done, take you off life support. Also, if you have to be moved into like a long-term care facility, then it's the power of attorney of personal care that handles that. The power of attorney for property it covers anything that you own. So it's called the power of attorney for property. You automatically think it's real estate, but it's any property that you own. So that would be bank accounts, the furniture in your house itself. So again, that's giving the authority to the named attorney to manage those affairs. So sometimes it comes up if a person is elderly and there's no chance that they're going to be moving back into their house due to their health care condition. The question sometimes is maybe you got to sell the house in order to come up with funds to pay for their long-term care. So if you have to make a decision to sell the house, the power of attorney for property will have that right, the ability to sell it if need be. And with the powers of attorney, the biggest single question is, who do you name as the power of attorney, as your power of attorney? And like with the wills, you would normally name a primary attorney. If you're married, you would normally name your spouse and vice versa. And then if you have to also name alternates, and it's the same questions that come up when you're considering who the executors and the alternate executors are. You have to name an alternate power of attorney, because it's prudent planning to have a backup person in place in case the primary person can't do it. So the question is, sometimes with the alternates, it might be quite obvious that you can name an alternate. The same person you name as the alternate, the power of attorney for property, is also the one in personal care. But in certain cases, some people feel that they're okay naming one person as the power of attorney for property to look after their affairs, like their real estate or their investments. But when it comes to taking them off life support or authorizing a medical procedure, there might be a specific person that they want to do that. As an example, sometimes some people may want a sibling to be the one to be the backup power of attorney for personal care, as opposed to their brother-in-law, something like that. So it really, at the end of the day, it's up to you and who you're comfortable with. Those are the main points that cover the wills and powers of attorney. And since people were asking about probate, I'll touch on the legal questions about probate. So there are some lots of questions about probate. What does it mean? In Ontario, when a person passes away, anything that they own jointly with someone else, under the law, will flow directly to the surviving joint owner. So typically, as an example, with real estate, most married couples own their home jointly. So when the first of the spouses passes away, the ownership, if it's joint ownership, the ownership will automatically flow to the surviving spouse. So, and it's the same thing if you have a joint bank account. If if you own stuff jointly in Ontario, when you pass, there's no probate. Under the law, it will automatically flow to the surviving joint owner, which is normally your spouse. You still have to file some applications and forms, either with the bank or through the law office, with the land titles office, to register it, but at law it flows automatically to the surviving joint owner. Where probate comes up is if you own something in your name alone. So you may have put a property into your name alone, or you might have a bank account or investment account that's in your name alone. Those assets that are in your name alone, they will not automatically flow to the beneficiaries under your will. What you have to do is you have to apply for probate. And what probate is you're taking the will, you're filling out a probate application, and you're submitting it to the court. The court reviews the application, and what's on the probate application is the list. Well, it's part of it's the will. It names who the executors are. It lists the assets of the estate. It lists the assets of the estate that were in the deceased's name alone. And your probate is the authority of the judge or the court authorizing the transfer of the assets out of the deceased's name alone into the name of the estate. It's sort of the court's blessing of what's under the will. And once you get the letters probate, then the executor of the estate is able to transfer the assets out of the deceased's name alone into the estate, and then from there they can be transferred out to the beneficiaries. So one of the biggest things that comes up with probate is if a person passes away and the house was in their name alone, then if normally the executors and the beneficiaries want to sell the house because the beneficiaries live elsewhere, or they need to sell the house because no one wants to own it. So you can't sell the house without probate. So there's always a bit of a rush with the law offices trying to get the probate applications in so you can be issued the probate in time to meet the real estate closing, because you can't sell the house without probate, and that's just the way it is. And as Fred mentioned earlier, and it came up, there is a fee with probate, and it's calculated based on the value of the property. It's a bit of a sliding grid, but for purposes of tonight, it's basically 1.5% on the value of an estate. So if you had an estate that was worth $100,000, the probate fee is $1,500, and basically if you have an estate that's worth $1 million, the probate fee is $15,000. And lots of people are concerned about probate because it can be a big number. Some people try to come up with these really creative ways to get around probate fees. And you can try to do that, but as Fred alluded earlier, it would be strongly recommended that you talk with your accountant, your financial planner, and your lawyer to make sure that if you're trying to avoid doing probate, you're not going to wind up creating a problem, a taxable event, or I can give you a long list of people who have tried to avoid probate and just wound up creating some more complicated situations for the executors. They had the best intentions, but it creates a problem. So you can try to do it. I can't get into too many more details at this presentation tonight, but all I could say is just make sure that, my recommendation is get strong professional advice if you're trying to go down that road. The best thing you can try to do when you're planning your estate is if you try to get things organized as best you can. Some people, pass away suddenly and haven't been able to get their affairs organized in a way that it's complicated and difficult for the executors to organize. Some people pass away and things flow normally the way they expect with the administration of their estate. Sometimes people think they got everything organized, and unfortunately they don't. One of the biggest problems that actually comes up with the state administration is a person passes away. The family members can remember that they did sign a will, but they can't find it. And it sounds sort of strange, but I can tell you several times a year during our estates practice, there's a big issue that they can't find the will. And I had one last month where it took about 3 weeks, but they finally found the will, and it was not where it was supposed to be. So one of the things you'll probably go over when you meet with your lawyer to do your will is you got to talk about where you're going to put it. And it's like what Fred had talked about earlier about putting a list together for the executor of where everything is. So everyone should be doing that. And what we always recommend in our office when we're doing the wills is you can get a safety deposit box at the bank. It's not hard to do. It doesn't cost a lot of money, but if you have a safety deposit box, you can put the will in there along with the powers of attorney and any other things that you have that are important. And if it's in the safety deposit box and everyone knows it's there, chances are it won't get lost. Some people will say they'll store it in their, their safe at the house, and then they forget it's there, or they move and the safe doesn't come along. There's a whole bunch of, well, you're all adults here tonight. I'm sure you've all kind of gone through one thing where something got lost. Losing the will is actually a big problem. It's correctable because you can apply to be, you can apply for probate without a will, but it's a lot easier if you have the will, and especially if the person went to the trouble of getting a will organized, then sure it'd be great if you knew where it was. But that's just basic organization, but it is a big thing. So I thought I'd mention it tonight. So.
Morton, microphone? Questions, folks? Got a whole bunch of hands, Ian.
So who is over here had their hand up first? All right, let's try. Manny, we'll go for you first.
Thank you for the presentation. My first question has to do with how often will you advise someone to review his or her will once it has been signed? That is one. And then secondly, to avoid paying the probate fees, you rightly talked about joint ownership. Is it also advisable from the legal point of view to put different people as joint owners for your estate? Let's say your building, your other properties, you put different people apart from your spouse. As a legal person, would you advise that? Thank you.
Okay. The first question about how often should you review the will, you probably should look at it maybe about every 5 or 10 years. Normally when you do the will, you've given consideration to your circumstances. Sometimes you can do a will. I've seen people that did wills in the 1970s and they never redid them because they never thought they had to change it. But for example, if there's been a change of circumstances, say for perhaps you did your will and you had named, say, your spouse as an executor. If your spouse passes away, while you may have named an alternate executor under your will, it would be good to update the will to name a new primary and then a new backup just in case. Similarly, if, say, you named for the guardians of the children, if you named your brother or your sister or brother-in-law and sister-in-law as the guardians of the children, and circumstances change that you no longer think they would be the right people to be the guardians of your children, then you should be remembering to update your will to reflect that change. So it's more really, if you think some of the circumstances have changed, then you should update your will, maybe every 5 to 10 years. But I can tell you, I've seen quite a few people that have been coming into our office in the last couple of years. They haven't looked at their wills in 30 years. But, or if another circumstance would be if you've become a grandparent, you may want to leave something behind for your grandchildren. So that might be another reason to redo the will. But you should look at it, I'd say at least every 10 years, because most people's personal circumstances, tend to evolve, maybe over 10 years at a time. Your second question about the joint tenants, I can't give you advice because I don't know the specific details, and I could say a few things here, but I don't want to mislead people on different ideas of how to do it. But it's certainly something you could consider, and it would certainly be worth talking, to your lawyer and your accountant of if there's an advantage to doing it. I can't say specifically whether it's a good idea or a bad idea, other than I would say it's worth considering, but you should, I would strongly recommend you speak with a professional about that.
Hi there. Hi, I'm curious about the power of attorney for health. If you're married and have a spouse and they become incapacitated for whatever reason, what happens when you don't have a power of attorney for health?
You've got a problem. So it should be a good. You can go get an application to the court to get someone named as essentially as a guardian of the person. The issue that becomes with the power of attorney for personal care is if there's been a medical emergency, the doctor or the hospital may need instructions on a very quick basis to proceed with a surgery or procedure, and trying to apply to court to appoint a guardian can take weeks. So the simple answer is if people don't have them, they should be getting them done up quickly. So.
Hello, this is really timely advice. We actually are in the process of purchasing property from an elderly neighbor that passed away, like your brother. So he was alone, he didn't have any will, and it's in probate process right now. So we're very early in the stages, and from my understanding, it's quite a process. I think it was like 2 months to close, but the tax on it is kind of news to me. So would that be closed off before the purchase of the home if we were to purchase the home? So we're not the executors or the beneficiaries, but we will be purchasing from them. So that process will be ended, and then that tax won't be tacked on to the cost of the home, right?
If you're talking about the tax, if you mean the probate fee,
Yeah.
The probate fee is paid by the estate to the court. It's
Okay.
not picked up on the real estate transaction.
Okay.
Yeah. But you have to have probate in order to transfer title. So an executor, can sign an agreement of purchase and sale to sell the property, but it's usually noted in the offer that probate has been applied for, and you literally cannot transfer title unless you have probate.
Yeah, they
Yes,
sort
yeah.
it. Okay, thank you very much.
Just on the comment about the power of attorney for personal care, there is actually a process in line for that. So you can name literally whoever you want. It's just a sheet of paper that you can print out. Anyone can go on the internet right now and print it out and name whomever. But if there's nobody, if you don't have that sheet of paper, there is actually a process in place where it goes through your next of kin. It would go to your spouse, and then to your sister and brother, and children and cousins down from there. But that
Yes.
yeah.
The issue is, with the power of attorney for property, it's not necessarily urgent in the sense that it's got to be done within 24 hours. Like, you can apply to the court to get a guardianship appointed, to sell a property, and it might be, 2 months, or to take ownership of a bank account might take a couple months. But the concern is always that if you're at the hospital and the doctors need authority, someone's in a coma or they're unconscious and there's a life-saving procedure that needs to be done, if the paperwork's not in place, you could be in a difficult spot. So I think some hospitals might have procedures in place to try to handle that, but I can't comment on the details. The best thing is just get something. Yeah.
Hi, I found out in my building that if something happens to me, nobody can go into my apartment and get anything. Say, a lot of times I go out to without taking my wallet because I'm always afraid to lose it. So, but if something happens to me out in the hospital, nobody can go into my apartment without a power of attorney. And I've been trying to figure out how do I make somebody a power of attorney so they can go in and get my stuff should I end up in a hospital like I did 7 years ago. You know what I mean?
Well, is your question how do you get a power of attorney? Yeah, you just lawyers prepare them. So yeah, you can fill them out online. My recommendation to get a lawyer, but you need to. That's one of the things you do. Get a lawyer to do.
I think what Paul was speaking to is how would he get somebody lawfully into his apartment, and I'm not so sure that a power of attorney is the way to do that. He's asking if something happened to him and he was in the hospital, someone has told him that they can't enter his apartment. So I think he's looking for a way that if he's incapacitated, someone is allowed in and do whatever he wants them to do.
Yeah, I would probably say, well, you talk to the landlord, and the landlord would be looking for some. Yes, I think you'd have to talk to the landlord, but I think if the landlord saw a power of attorney that he had signed authorizing that person, the landlord would probably, well, they'd be very cautious, but I think the place to start would be the power of attorney. But you might want to check with your landlord to find out what they would, it might be a good question to the landlord, but I think a power of attorney would be the place to start.
Hello, is this one? Okay. Hello. For someone who has a small business, what advice would you give them to be prepared?
Well, you should do a will and keep in mind that you have the business. Probably go meet with your lawyer and your accountant to do some planning that what would be the backup plan if something were to happen to you. Usually with these things, if you meet with your lawyer and your accountant and your financial advisor, they'll probably ask you certain questions, how you want it to be handled if you were to pass away. But most of the professionals that deal with small business owners have got experience answering the specific questions that are on your mind. So my recommendation is you probably make an appointment with your professional advisors and try to put together a plan.
You got a lot of questions here today.
My question is about online wills. Are they the same as, or I guess I've never tried to do it online, but if you were to do one app, will it have the same information that you mentioned? Similar to if you were to do one with a lawyer. So like such as you need an executor and then you need the alternatives, all that information, will that be put into an online will? And can you take that to court for probate?
Yeah,
Or do you
I'm
have
not
to
really
get
sure
a
what an
lawyer
online will
involved?
is.
Okay.
There's I want to speak favorably of my profession. I think it's better in general if you get a professional to prepare it. I have seen some online wills. The whole idea of getting a professional to prepare it is that this is part of what they do for a living, and they deal with these sort of questions and issues regularly. And the wills that they're preparing, they prepare them on a regular basis, so they know the points to cover. The other issue, which I didn't speak about during the presentation, but I can answer questions later, is you have to make sure that the wills are properly executed. So in Ontario, you have to, if you're the executor, you also have to have 2 witnesses to the will. And I have seen some cases where people, pulled wills offline and prepared them on their own, but then the problem was they didn't have proper witnesses. So that's one of the reasons that you would hire a lawyer to do it, because they'll make sure it's done properly.
Obviously, we appreciate Ian's knowledge and his good answers. Thank you very much, Ian.
So just quickly, Ian, you're okay to answer some questions at the end too? I can see there's still a lot of questions, so yeah, go ahead.
Yes, and also I will tell you this, that executors rule. And so I really hope you heard what Ian had to say, because at my office, people tell me, yeah, but that's my husband, and the neighbor is the executor, and I need to talk to the neighbor. I can't talk to your spouse. So executors rule. Picking an executor is very, very important. And I might also tell you, whatever else Andrew or Fred or I have to tell you, the best advice you got in the last few minutes was the word joint. And I love Ian and Mac. They've been friends of mine forever. There's 230 lawyers in the phone book. Pick any one you want. I always pick Ian and Mac, all right, kind of like the church, because they're honest and they do a good job. But to the point about joint, if it's joint, it moves over to the survivor. So if any of you have bank accounts only in your name, don't do it, all right? Put a joint on your bank account. And my argument always is, if you're willing to do a POA, power of attorney, joint survives from life to death, POA stops when you die. And that wasn't said this evening. So people come into my office and say, Jerry, I got a POA. And it's like, too bad, because it means nothing to me right now. So where is the will, or where is the joint? So please keep that in mind. Chantel, to your point, when you die intestate, which means you don't have a will, it does revert to relationships. And by the way, in Ontario, there's no such thing as separated or common law. Either you're single, married, widowed, or divorced. There's your choices. So people again will come into my office and say, oh, well, we're a common law. Well, no, you're not, okay? That doesn't count in Ontario. Now that's where joint does kick in. So when Ian gets out into that courtyard, you can just bombard him with lots more questions, because this is my life and I deal with Ian and Mac on a regular basis. My mother died 19 years ago. Everything went to my dad. Dad put Joffrey and I joint with him. Dad died 10 years ago, and his personal stuff, Joff and I directly inherited. The corporate stuff had to go through Mac and Ian. So again, the planning is really important. Yes?
Can I just one question, because I think it'll apply to everybody, but is there an expectation of a percentage that goes to the executor?
2 to 4%.
Yeah, at law, there is. So at law, under the Act, there is compensation that an executor is allowed to charge, and it's 2 to 4%. But some executors will, some will actually waive the fees. Like if it's your spouse that's passed away, you probably won't charge your spouse's estate. But some estates, certainly if you name a third person to do it, they're entitled to compensation, and they're entitled to expenses as well. So they have to report it to the beneficiaries. Like it's not a free ride. They got to justify the expenses. They got to keep track of it. But if you're doing the work, you should be paid for it, and that's what's reflected.
And your most expensive executor is your bank or trustees, because they charge full freight. So be aware of that as well. But then also, in my world, to your point, Fred, I have a set of ashes in my vault that have 6 siblings with 6 lawyers that are all arguing about where their mother's ashes can be buried. So you can imagine how the estate's being settled too. When they can't decide where to bury the mother's ashes, there's 6 lawyers that are very happy in Sudbury because they're billing to find out what's going to happen next. So it's very important to get things properly organized. And on that note, perhaps not a member of the church, and perhaps not an extended member of the church, but when I called John Neely, who many of us know, I said, who should talk about financial planning? He said, absolutely, Andrew O'Brien. He'll talk about financial planning. Please welcome Andrew up to our microphone.
Hello, my name's Andrew O'Brien. I do work with John Neely. We're both independent financial planners. As you know, he's a member of the church, and I work fairly closely with him. I knew we would have a lawyer and an accountant here, and I thought they were mainly dealing with estates, so I can talk about some things like that. I did have a couple of things I would talk about, a little more financial planning, and then I'll talk about a few things that happen when you pass away as well. One thing I just want to let people know, there is a brand new plan that has come out, and I wanted to kind of judge the audience, and we have kind of a whole range of ages here, and this might not apply to any people, and it might apply to some people. There is a first home savings account, and even if someone is older, maybe it's a way to give money to a child for them to buy their first home. It's kind of a hybrid between an RSP and a tax-free savings account. The money that you put in, you get a tax deduction for, just like an RSP. But if you are considered a first-time home buyer, that's the first case. You have to be considered a first-time home buyer. Again, you get a tax deduction for the money going in. If you purchase your first home, you can take that money out tax-free. And unlike the home buyer's plan, you don't have to pay it back. So it's a pretty powerful way to get younger people to possibly buy a home, or maybe a grandparent or a parent to possibly give money to help a child buy a home. The second thing I was going to talk about is I get this question all the time about CPP, when you should take it. Some people, I'm sure, have already made that decision, and some people maybe are getting close to make that decision, and some people probably have never thought about that decision. And the one thing I would say, it is different for everybody. Just because Johnny down the road said it's the best to take it at 60, or Billy says it's best to take it at 65, it really is an individual thing, depending on your situation. Again, we don't know how long we're going to live, but there are, in pure dollar terms, the longer you live, the more it makes sense to wait for your CPP. If you take it at 60 instead of 65, the break even is age 74. So at age 60, you get a 36% reduction in your CPP compared to what you would get at age 65. So the person that waits till 65 would end up receiving more money as long as they lived more than 74 years old. So just one way to prepare for retirement, which usually comes before you pass away. Now, getting more specific to some of the topics tonight, we've talked about probate and avoiding probate, and one of the big ways is to name beneficiaries. And if you have either an RSP or a RIF or a tax-free savings account or this new first home savings account. So anyways, if you do name a beneficiary, it avoids probate, but you can, typically it's the spouse, and if we're looking at RSPs or RIFs, you avoid the taxation when the money is passed from one spouse to the other. But if it's a non-spouse, if it's a child under 18, you can delay tax for a few years until they turn 18. It gets spread out over the years that they're under 18. It doesn't usually happen, but it can happen. But if you name a child as the beneficiary, then there is tax in the estate. So I wanted to kind of give an example where someone I know possibly was going to make an unintended consequence. And I'm going to use round numbers, and you can add a zero or take away a zero, because 50,000 to someone might be their situation, 500 to someone might be their situation. But in this case, it was a second marriage, and both the spouses agreed that the money that they had before they got married should go to their kids on both sides. Now, one of the spouses, and I'll make up a number, let's say their only asset was an RSP, and it's $500,000. So he names his kids as the beneficiary of that RSP, and they both agree on that, but she is the executor of the will. The $500,000 is the only asset. He passes away. That's considered like he sold that $500,000 the day that he passed away, and there's roughly $200,000 to $250,000 in tax, which goes to the estate, but the $500,000 goes directly to the kids. So now, if the kids and the surviving spouse are all on the same page, the kids would probably willingly give back the money so the estate can pay that tax. But if they're not, then the estate would have to probably sue the kids to get some of that money back to pay the tax. So there can be unintended consequences, and it just makes sense, like Ian was saying, and that you should talk to a professional because everyone's situation is different. You don't want things like that to happen, and so maybe in that sense you leave enough of that $500,000 RSP to the estate so the executor has enough tax, enough money in the estate to pay the tax. Even though they're going to pay the 1.5% probate, it's probably a lot cheaper than someone having to sue a beneficiary. What else was I going to say? Other thing, again, in the tax situation, whether it's on the second spouse, when there are like large taxable assets such as RSPs or RIFs, or if there is a second property that doesn't fall under the principal residence exemption, there can be a big tax bill. If you think of, I mean, it's happening around here too, like a lot of second properties on the water have gone up significantly in value. But imagine if you had a place in Muskoka, it was a family cottage for 50 years, bought for $100,000, and now it's worth $4 million. The second spouse passes away, you know, roughly half of that, there might be a $2 million tax bill just on that second property if it's not considered the principal residence. There are ways, if you're looking to keep that in the family, usually people will set up a life insurance policy so there's enough money in the estate to pay that tax bill when it's due. Especially if the kids wouldn't qualify for a mortgage on that place, and then that family cottage would have to be sold. Again, the numbers can be different. They can be significantly lower. I'm just trying to think of some round numbers like that. Again, filling in for John. I haven't talked in front of a lot of people for a while, so I apologize for my nervousness. The other thing, I know John Neely deals with a lot. He does a lot more life insurance than me. I know a lot of people going to the church here and doing tithing and stuff, often with a life insurance policy, or even proceeds of the estate. Often they'll name a charity, whether it's the church or the Red Cross, things like that. Especially if there is it doesn't have to come directly from the estate. Like, it could be an asset that has appreciated, and there would be a tax bill in the estate. But if it's given to a charity, and Fred could talk probably more about this, that you can avoid that tax. Now you're giving that piece of property or whatever that, maybe it's a stock or a bond or a mutual fund, you're giving that asset away, but the estate doesn't have to pay tax on it. So that's often done. Like I said, I wasn't sure I'd be talking more about what happens when you pass away. I kind of had a few other things beforehand, but I don't know if people have questions. And
Thanks, Andrew. Can you just clarify a little bit how money can be left for grandkids? You mentioned the new account.
That I was thinking more as when you're living. It's just a powerful way for them to get a tax deduction. They don't actually have to use that tax deduction if their income doesn't warrant it. They can carry that forward until they get into a position where they can use it. When you first open that account, you have 15 years to buy the house, to buy a qualifying property. After 15 years, or if you're turning 71, whatever one comes first. Or if you don't buy a house, it would just roll to an RSP, or you could take it out and it would be taxable. 40,000 can go in, but the maximum is 8,000 per year. That's the other thing I forgot to say. So the quickest you could fund that is in 5 years.
And what happens if it's not turned into a home purchase?
Yeah, so if it's not turned into a home purchase, if you take it out, it's taxable, or it can roll tax-free to your RSP that at some point would come out taxable either as lump sum withdrawals from a RSP or a RIF if it turns into that at whatever age you decide to turn it to a RIF. Thanks.
Hi. So my question is, say you have an FSHA account and you have an RSP, and then you want to make the your first home purchase. Will there be implication, or can you actually combine the two? Say you have the two accounts and then you have money in both of them. Can you use both of them to just?
So you can have both. So say you have filled up your first home savings account, and if you put 40,000 in over 5 years and it's grown to 45,000, you can take whatever that value is. If it's 45,000, you can take that out once you're buying your new home. You can, if you had money in your RSP separately, you can still do the first time home buyers plan up to 35,000. So so that one's a fixed number, the 35. The first home savings account, you can put 40 in. It could be, well, depending on what investment you've put in, it could be worth more than 40 or it could be less than 40 when you go to purchase it, but you can do both. The other thing is you're allowed to make transfers from your RSP to this first home savings account. So the only difference is you don't get a tax deduction for moving the money from the RSP to the first home savings account because you've already received the tax deduction, but now you can take it out tax-free. So if you were considering only doing one, to me the home buyer's plan does not make sense anymore because you can move that money over to this first home savings account, take it out, and you don't have to make the repayments. Now, you're taking money from your retirement, so there's like a give and take, but it's a great new plan.
Fred?
I was just waiting to see if there was any more questions, because this isn't really a question, but Andrew touched upon it, and sometimes we don't talk about it enough, but I'm going to make a shameless promotion that if you're someone that believes in giving, and you're giving now, don't forget to include someone, well, I'll tell you, put an All Nations Church in your will, okay? And because that's your intention. Your intention is to support. And you can put anything there other than All Nations. That's the shameless part about my promotion. But if you have other charities that you believe in, put them in your will. I often talk to people about having another child as a beneficiary, and that child is named charity. So most people that have lived a long and successful life, they've got money that if their kids, I see it all the time. I'm not going to say most people or all people, but quite often I see a situation where people pass away. They needed their money in case maybe health was an issue or something a lot more than their kids. Their kids might be, high income earners that have no debt or whatever. Now, I'm not saying don't give your money to your kids. I'm just saying consider. If you got 3 or 4 kids, well, is 25% going to be a whole lot different on their life than 33%? It's going to make a big difference to a charity that you care about.
Ladies and gentlemen, Andrew O'Neill with some good financial advice.
And if anyone has questions afterwards, I'll be around.
You'll
as
be in the
well.
courtyard.
Yeah. There was a question for Mr. Sinclair about how often to look at a will, and you mentioned it, but anytime there's some kind of material change, especially if there's a second marriage, extra kids, all that, because I've gone to so many seminars where a will hasn't been looked at for 30 years, and second marriage, the first husband is the beneficiary and hasn't been in the picture for 30 years, and it's a nightmare.
Welcome to my world, Ian. Andrew? So actually, on that happy note, the elephant in the room is the word divorce. And if you have a will and you get divorced, you better get a new will, because that divorce will nullify the old will. And it can create a lot of angst and a lot of stress in the families. And to your point, Fred, absolutely. In terms of my own will, I have beneficiaries with regard to my family members at a certain amount of money, and then after that it will be divided between All Nations Church, Finlandia, and the mission, so that there is always that balance that you have in terms of what you think is fair to your family, and then to the point about what you believe in, and this is what we believe in. And very much I might suggest investments are important, and I might also suggest, Andrew, to the point that you made about listing them down, because there is no such thing as a bank registry, just so you know. And there is no such thing as an investment registry, just so you know. So if you don't tell your family where your bank books are, or your investment statements, or worse yet, even who you invest with, they're really at a loss. So make sure that list is made and make sure it is updated. There is no question about that. What we didn't talk about tonight, Ian, is the last will dated is the will in enforced. So that 30-year will that Ian talked about, that could be it. But if you made a will a week before you died, guess what? The week before you died will is the one that's in force. So that date is very important. So you come to me. This is ultimately the last guy to let you down, the undertaker, in terms of talking about be prepared. So I'm Irish, as many of you know. Obviously, Andrew, you must have some Irish genes in you with O'Neill. So God bless my grandmother. She came from Donegal, Ireland. And when my father would visit her in Wheatley, which is outside of Windsor, and my dad had been a funeral director forever, Graham would say, now, Gerald, she always called him Gerald, I don't really want to hear about what you do at your work. And then I got to be an undertaker, and she said, Jerry Jr., I really don't want to hear about what you do at your work. And then Joffrey got to be an undertaker, and she said, Joffrey, I really don't want to hear what you do at your work. Because my grandmother was under the impression if you started talking about funerals in her house, inevitably somebody had to die to fulfill that conversation. Now, she also believed if a bird flew in the front window of your house, it meant somebody in that house would die, all right? And she also believed if the dog barked in a certain direction, a neighbor would die in that direction. And we used to say, Graham, I think they sit up in the Ireland thinking about ways to die, because it didn't matter what we did, somebody was going to die, obviously, that was the case. So my grandmother would never, ever, ever prearrange her funeral. Absolutely not. And it really took us a lot of convincing to actually make her joint with my dad and my uncle with regard to her estate. Because she said, it's my money. I'm going to look after it. You boys, you'll get it when I'm dead, but I'm running it now. And then we told Graham about the taxes, and we told Graham about how it could get frozen. We told Graham, we haven't talked about that word public trustee either tonight, that the government can even take over your estate. My grandmother hated government. She lived through the Depression when banks actually went bankrupt. So then she decided it was okay to have my dad and my uncle be joint on her assets. So the presentation is very important. And tonight, you're brave souls, all right? Because we said, be prepared. Sean and I thought this would be a good idea. The elder said, let's see what happens. And 50 people show up, so I guess something happened. But in fact, if you had told somebody in your house tonight, oh, I'm going to the church, and I'm going to hear about how to prepare to die, their answer might be, I didn't even know you're sick, Luke, and now you're preparing to die. All right? We make the assumption, if we're talking about funerals, inevitably, we're going to have some sort of death experience. That's nonsense. All right? And that's why we use the Boy Scout motto, be prepared, for this seminar. Being prepared costs nothing, but being prepared really helps people. And that might be my argument, my suggestion, my thought that I want to put in your heads about prearranging a funeral. Prearranging a funeral costs nothing. You can go to one of my funeral homes, you can go to the co-op, you can go to Rangers, you can go to Simple Wishes, you can go anywhere you want. There is no charge to pre-arrange a funeral. Basically, a pre-arranged funeral is just information. 3 types of information: vital statistics, because the funeral home or cremation provider is the source of the death certificates. And there's some really weird mentality out there that somehow HSN provides you with death certificates. No, they don't. To help a little bit with documentation, there's something called a medical certificate of death, which the doctor must fill out, and that goes to the provincial government, and that allows you to be buried or cremated. That document is not accessible to you. That's between the doctor and the provincial government. We issue you proof of deaths or death certificates for legal purposes. People like Ian love my death certificates. People like Andrew, the cash in investments, like my death certificates, and people who file income tax love my death certificates. We start everybody off with about 12 death certificates, and we'll give you as many more as you want. There is no cause of death on a death certificate. And that's, again, another wonderful kind of urban myth. And I'll actually have people bring them back and say, Jerry, your staff forgot to put the cause of death on. Under the confidentiality laws of Ontario, you cannot put a cause of death on a death certificate that is used for legal purposes. Why? They don't want the bank tellers necessarily knowing that your father died of cirrhosis of the liver, or somebody committed suicide, or somebody had SARS, or somebody had COVID. So a cause of death is never disclosed except with the permission of the next of kin, executor, or family members that are privy to that. And even the autopsies are ordered by the coroner. And they can, in fact, I talked about executors ruling, coroners rule in Ontario. If a coroner orders an autopsy, you're going to get an autopsy. And you may say, whoa, wait a minute, I don't want an autopsy. And people that are Jewish faith, Muslim faith, and people just don't like autopsies will say, I don't want that. The coroner can override you. It's interesting that the coroner represents the deceased, which sounds very kind of peculiar because the deceased is dead. What's their voice? He or she is the voice, the coroner. So the autopsy is done by a pathologist, and the pathologist takes the findings of the autopsy and sends it to the coroner. The only people that can get that result is your executor or your legal next of kin. And you have to request that. That's not automatically sent to you. NOSM uses virtual software with regard to teaching, with regard to dissecting bodies, as they like to call them, cadavers. Toronto and other places in southern Ontario still have or body donation. To donate your body to science is a complicated procedure, and if you're considering that, I suggest start working on it now. And the other really weird thing about it, they only want healthy bodies. My experience would be if you're healthy, you're liable not to die. That would be my hope, but having said that, they don't really want bodies that are ridden by cancer, etc., because they're teaching doctors where all the proper organs are, etc. They keep the bodies for about 2 or 3 years, and then they're cremated. They'll either leave the ashes on the University of Toronto property, or they'll send them back to your next of kin. But most people need to plan a funeral or a cremation locally. So again, back to a provider, a funeral home or cremation service. There's 4 of them in Sudbury, and they're all pretty reputable. So I have absolutely no problem saying whoever you would call would have you have some good information. Does not cost you anything. Why do you do it? First off, obviously, you get what you want. So you say, hey, you know what? I don't want this, or I do want this. I'd like to have a church funeral. I'd like to have a chapel funeral. I don't want any kind of religious funeral. I want to be cremated. I want to be buried. I don't want an obituary. I don't want to be embalmed. I do want to be embalmed. I want this particular kind of clothing to wear. By pre-arranging a funeral, you're actually putting your request down. Any lawyer worth their salt will tell you, don't put that in the will. Because guess what? Lawyers go home at 5 o'clock on Friday. If the good Lord calls you for glory at 7 o'clock on a Friday night, it might be awkward to get the lawyer to go into their office on the weekend to find out you wanted to be the blank. Cremated, buried, all the things I just said to you. So a good lawyer is going to say to you, why don't you go to a funeral home or cremation provider and pre-arrange that? Because good old undertakers, we're there 7 days a week, and we answer the phone 24 hours a day, so that you can access your records quite quickly. But again, if you're in glory, you're talking to the Lord and all your other relatives. So you won't be talking to the earthly people anymore, but the earthly people might want to know what's in that file, so they kind of know how to plan the next steps. So you're going to get what you want. what did I just allude to? It helps your family. So by prearranging your funeral, you're taking a burden off your family because, in fact, they know what you want. Not 48 years, friends, I've been being a funeral director, so that's a lifetime. I've been a funeral director longer than some of you have been alive. So on that basis, I can tell you all the horror stories if you want. I can tell you about fist fights in my office, if you'd like, as recently as last January. All right, 2 sons and a daughter are sitting there, and they whipped out the obituary. The mother had prearranged a funeral, thankfully, so I kind of knew what I was doing, but we have to update obituaries because there's grandchildren, and there's great-grandchildren, and there's divorces, and there's dead siblings, so you have to kind of update an obituary. And the one son whipped it out, and he gave it to me, and the other son said, "Mr. Loughy, could I see that?" I said, "Sure." I gave it over to him. He looked at it, and he just got furious. And he looked over at his brother and his sister and said, "You did this when our dad died, and now you're doing this again." And he's just getting really, really upset. And I couldn't understand how an obituary can get you that worked up. And then he said, "And you left my wife out this time, and you left her out the last time." Now, as good Christian people, brothers and sisters in Christ, I'm sure you would have said, like I would have said, "Oh, we forgot. Let's put the name in." No. These 2 people looked over at their brother and said, "Mom never liked your wife. We never liked your wife. That's why we didn't like you coming at Christmas time, and we're really happy we didn't put the name of the obituary," all right? They jump up, all right, and they start pushing one another in the undertaker's office, all right? The one guy was in pretty good shape. He was kind of like Sean, all right? And he grabbed his brother and put him right up to the ceiling in my office and started pounding him there. I think he was a hockey player as well, because then he put him down and took his hoodie and put it over his head, and then he just really started to pound on him, right? This is quite entertaining for an undertaker, I can tell you that, all right? So having said that, my brother said, "What'd you do?" I said, "I channeled our Father." He said, "What'd you do?" I said, "Boy, stop that right away. You go sit in the car. You sit on the chair. I'll deal with you afterwards." Joff said, "What did they do?" I said, "The one guy went up to the car. The other guy sat in the chair," all right? So I got to tell you, if you think you got acrimony in your family, everybody's got a little acrimony, unfortunately. But if you plan your funeral, you're alleviating a lot of discussions. Because I will tell you, even if people don't get along as family members, they will respect the fact that Mom wanted this or Dad wanted that. The only thing I would caution against is to make sure that you don't make your family members spectators and not participants. Some people organize stuff to such a degree the family have no input. Families have to understand that they are taking ownership of that experience. And again, I smiled. Fred, I think you had a 5 and 10 year plan. I think, Andrew, you were kind of adhering to that. I got to tell you, but for the grace of God go I, nobody knows what the future is. You may have a 5-year plan, and the Lord's got a 5-day plan for you, all right? So you don't know what's going to happen. So if you said, guess what? I've got a 5-year plan, and you know what? I'm going to be in the hospice for like 2 months before I die, and my family can all come and see me. And that, therefore, when I die, I don't want anybody looking at my body. I don't want any open casket. I just want to go and be cremated or buried, because everyone has had a chance to say goodbye to me. On the other side, if today you're a bit overweight, you haven't exercised very much, and you got your rake, and you started raking your yard, and you had a heart attack and dropped dead in the front yard of your house, which, by the way, is exactly how my grandfather-in-law, he died. We weren't planning for Granddad to die that way. So we needed to see his body to give us closure to say he's dead and we got to move on. So you always need to leave the option, say, this is what I want, right, under these circumstances, but I will defer to my spouse, my kids, my executor, if they want to make exceptions for them, not necessarily for the public, but that extra decision-making I will allow them to have. You don't have to pay for anything, as I've mentioned to you. Some people say, yeah, but Jerry, I see this prepaid funeral stuff. Yeah, you can. If you prepay a funeral, you literally freeze the price of the funeral. So you paid 2023 prices, you die 10 years from now. That money is not put into the funeral home's current account. That money is put into a trust account. The interest on the money cancels any inflation. So if you die 10 years from now, under provincial law, not Jerry Lougheed law, under provincial law, there can be no billing to your family or to your estate because you prepaid your funeral with a contract. The fact of the matter is that if there's a shortfall, and if you think about it, interest has not been that kindly over the last few years, there likely would be a shortfall. The funeral home must absorb the shortfall. So there cannot be any extra billing. And in fact, in our funeral homes, we give a 10% discount at the time of purchase. So inevitably, every one of our prepaid accounts has a shortfall. Inevitably, we have to absorb that shortfall. But that's the one advantage for a prepaid funeral. In fact, I see a couple people here today that I know have done that. And I tell people, if you own your own house and you're financially stable, you're likely farther ahead to keep your own money and invest it, because you'll likely make more interest than giving me the money, because you lose control of the money. So if you give me $8,000 for a traditional funeral and then you don't die for 20 years, for $8,000 for 20 years, you have no access to it. You can cancel and get a full refund at any time, but you can't take the money and go to Florida. You can't give the money for a tuition for your grandchild, etc. So if you own a house and you've got insurance and you've got an estate that could pay for your funeral, I say, you know what? Go prearrange your funeral, get everything you want. I'm not sure I'd leave the funeral home much money. Having said that, the day you sell your house, the day you move into an apartment, the day you move into a senior's residence, the day that people start taking your principal away from you, yeah, go in and pay for your funeral, because that way they cannot touch prepaid funeral money. If you cash it in, and we have a lady in the South End, God bless her. I think she went to one of my talks 20 years ago, and she decided that we were the best tax shelter in North America. So she ended up putting about $30,000 into our prearrangement trust, and she wanted a direct cremation, which cost about $2,500. And we knew that because we knew what the file was. And we kept saying to her, why do you keep sending us money? And she says, because they don't have to pay the tax. Well, yeah, you're going to get a refund, a rate of $27,500, and you'll pay the T5 to your estate. So that is not a good manipulative way to avoid taxes, I can tell you that as well. So you get what you want, you alleviate the burden on your family, you can prepay it. Canada Pension, somebody alluded to that. I think it was you, Andrew. Canada Pension started in 1966. If you've worked accumulatively 10 years since 1966, you are entitled to a $2,500 death benefit. That death benefit is supposed to go to funeral expenses. Back if you have prepaid your funeral, the estate still gets the $2,500. It was being taxed up to a couple years ago, but now it's not personal taxed. It was personal taxed up to 2 years ago. So yeah, so that $2,500 for most people was like $2,100, but there was enough complaints about that. Supposedly, Mrs. Freeland or whoever it is going to increase the death benefit next year. I'm not holding my breath for that. If you're a spouse, you're entitled to a monthly check of up to $693 a month as a spousal benefit, and that is ongoing. The fact of the matter is, common law relationships count as spousal relationships with the federal government after 2 years. If you have children under the age of 16 or over the 16 still going to school and dependent on you, they get approximately $200 a month from Canada Pension. So Canada Pension definitely has death benefits. If your workplace, you have a collective agreement, you should double check to see what the death benefits are and what the pensions are as well. For example, Valley from the 1998 contract till now, if you're an hourly man or woman, $5,000 death benefit, usually 50% of the pension and ongoing drug plan. Glencore/Falconbridge, a little more generous, $6,000 death benefit, but the Falconbridge people, Glencore people, also give that benefit to your spouse. So the man worked at the mines, died, this is your grandmother, and then 10 years later she dies, she'll get $6,000 from Falconbridge as well. Veterans, everybody says, oh yeah, but my dad's a veteran. Veterans have very much a means test, and if you have more than $25,000 jointly in your accounts, you're not going to get any veterans benefits. You can get veteran benefits when you're alive, but it doesn't count afterwards. Workman's compensation, I hear that all the time, but Jerry, Dad was on workman's compensation. A back injury doesn't kill you, so you're not going to get a death benefit. But if you have workplace carcinoma, you'll definitely get death benefits from workman's compensation and pensions for your spouse. So again, the cause of death is very important to that. But let's say you've got no money, okay? Got no money, no money. There is no law in Ontario that makes somebody pay for somebody else's funeral. So in that situation, ODSP will pay for your funeral or your cremation. We have a great humanitarian ODSP in Sudbury. Many jurisdictions cut off ODSP at age 65. Our people don't. So you're 82 years old, you're living on your senior's pension, you got no money in the bank, you got no insurances, no other assets, and you die, your family, your relatives, your next of kin would not have to pay anything. We put an application in a ODSP, and that grant pays for everything. Back to the joint stuff. Amen. I talk everybody in my talks, joint, joint, joint. If you got anything in your own name, you're a foolish person. All right? And the probate will kick in. There's no question about that. The probate taxes, the lawyer's fee, and the court disbursements are legitimate expenses if you're going through the will. But the fact of the matter is joint sometimes avoids that. And the other thing is, if you're going to buy insurance, please don't put the estate payable beneficiary to the insurance. Insurance does not go into your estate. It goes to the beneficiaries, so put names. And you can put more than one name, by the way. The equity with your kids, you can put 2 or 3 of your children and be the beneficiaries, no problem at all. Sorry? It's a church too, that's right. Put the church down, that's right. Fred's doing a bit of a tithing mission tonight, and I'm very much with him, so there's no question about that. Embalming. Embalming is not, I still give talks in the school, and I always like it when I talk to the little kids, because the little kids are always kind of really funny. Actually, I go down to like a grade 2 level. You always say, yeah, boys and girls, how old should you be when you die? Oh, they all put up their hands. Remember when you wanted to answer questions, dislocate your shoulder, please pick me, please pick me. We get older, sit in our hands and say, oh, hope he doesn't ask me anything tonight. The fact of the matter is, you say, how old? And they say, oh, Mr. Lougheed, you should be really old. He said, well, boys and girls, how old is old? And he said, well, Mr. Lougheed, at least 40 or 45 years of age. The teacher goes home thinking half the class thought should be dead by nightfall. But having said that, old, for the definition for all our benefit, is 15 years older than you are today. And 15 years from now, you'll reassess again. So the fact of the matter is old keeps moving in our lives, all right? The person I love in this church, and you all love too, our matriarch, Jean Mahood, 98 years old, living in her own house, no PSWs, no Meals on Wheels. There she is, independent. And I know you've all heard me say this from this platform. I want to grow up and be just like Jean Mahood, all right? Because that age number means nothing if you've got your autonomy and your independence. So this whole planning, and Sean, I'm going to use the best example going. So he said, I think we should have a seminar. And Sean said, okay, that's okay. Okay, and then he said, why would I want to come to the seminar? Okay? Now, Sean's likely the most fit guy in this room. I think, well, Manny, you and he could have a bit of competition, but I'm going to, for my purposes, say Sean's the most fit guy in the room, okay? So Sean is, why do I need to be prepared, all right? Like, I'm going to live I'll be to the 98 too, Jerry, not a problem, all right? And then I said to Sean, you really like that motorcycle? He said, yeah, I love my motorcycle. And I said, gee, Sean, if you're driving your motorcycle and you fall off your motorcycle and hit your head and go into coma, do you think you might want to go to the seminar to hear about POAs, about who can unplug the machine or plug the machine in? And then Sean said, I'll definitely be there. There's no question about that, all right? So I don't care who you are tonight or what age you are tonight. What you heard tonight likely can kind of help you. So back to that embalming thing. Embalming is not some mystic ritual, all right? Why do people get embalmed is basically to restore the body so it looks some sort of normalcy, to preserve the body, to allow people to gather for it, and for some situations such as COVID, to disinfect the body. So embalming is not, back to these little kids, Mr. Lougheed, my older brother says embalming is when you hang them up by the toes and cut their armpits and drawing all the blood out. I want to meet your older brother, okay? You're just scaring whatever out of the little guys in your family, all right? Embalming is a small incision, this long, made over 1 or 3 places. Your collarbone where your carotid artery is, your armpit where your axillary artery is, or your thigh where your femoral artery is. When you're dead, your heart doesn't work too well, so we have a machine called an embalming machine because undertakers aren't very creative. So we have an embalming machine, and we hook it up to your artery, and we put some water and formaldehyde in it, and we embalm your body and remove the blood. A normal question, by the way, by the high school kids is, hey, Mr. Lougheed, why do you remove the blood? You know, couldn't we use the blood? Interesting, in Russia, they actually use cadaveric blood. We don't because, guess what? A lot of people didn't come to the seminar tonight because they don't want to have anything to do about death. So when they get up to the hospital and the nurse says, hey, we got this dead guy's blood. Oh, I think I'll pass on that. I'll wait for the living guy's blood to come. So we don't keep dead people's blood, all right? When they do the autopsy, all the organs have to go back to the funeral home, except the pituitary gland. Pituitary gland is legislated, and it has the growth hormone for people that suffer from dwarfism, and that's the only thing that they can keep from your autopsy. Everything comes back to me. So that embalming is done for what? To basically confront that you're dead. If you don't need that, if you've had lots of time at the hospice, you've had lots of time at the nursing home, don't worry about it, all right? But I know that I buried my brother-in-law last week, and his mother, who's 91 years old, needed to see her son's body because she needed to confront the fact that he died in Montreal, and she needed that closure. So that's why it's not a pleasant experience. All right? My grandfather McIntosh, he said, I hate going to those funeral parlor places. You go to those funeral parlor places and they go and look at the dead guy in the coffin and they say, oh, doesn't he look good? I'd rather be yellow as a duck with jaundice, looking terrible, walking around than looking good in a box, all right? So I understand my granddad McIntosh real well, all right? And I don't disagree with him because it's not a pleasant experience. But for some people, it's a necessary experience. But you're not automatically embalmed. In order to be embalmed, permission from your executor, your next of kin. I live with those executors, by the way, and I live with those next of kins. And that's not a gray area, that's black and white. Cremation, we have an 81% cremation rate in Sudbury. We're one of the highest cremation rates in North America. Crematorium is about 1,500 degrees Celsius for 2.5 hours. If you really want to win a toonie after tonight's presentation, somebody who didn't come here tonight, you can say to them, I'll bet you a toonie that you can scatter your ashes anywhere you want. And they're going to say, oh, no, there's laws against that. I know there's laws against that. Well, they know nothing. Just so you know that. There are no laws that govern ashes in Ontario. You can do anything you want with ashes. So you can keep them, you can scatter them, you can put them in your house, you can put them in pendants, you can do anything you want with ashes. There is no restrictions about ashes. You're basically getting back the bone ash because of the heat of that crematorium, and there's no environmental impact of that. Speaking a little bit in the religious vein, there are no faith restrictions to cremation. And some of our evangelical brothers and sisters in Christ like to tell you there are, and they're not, okay? So a person of faith can be cremated if you're being cremated for the right reason. Not to get into some great theological discussion right now, but I think some of you heard the sermon. In fact, I'm working on villains right now for my brother Sean, and we're going to talk about Judas, and Judas is going to hang himself in the book of Acts. And what happens to Judas? His bowels burst, all right? And if you want to know why his bowels burst, is because in the early days of the church, in anatomy, they actually believed your soul was in your bowels. By recording his bowels burst, it said his soul was destroyed. So the early pagans would say, oh, you Christian people, you know what? We're going to burn up our bodies and we're going to burn up our souls, because they thought the soul was like a liver or a kidney or a pancreas. Well, we've enlightened ourselves since then. So being cremated does not destroy your soul. So on that basis, anybody can be cremated. We don't have a lot of cemeteries in Sudbury, and the ones we do are pretty much full. Park Lawn, Sudbury Catholic Cemetery, the Anglican Cemetery. Over every casket burial, you can bury 4 sets of ashes. And if you want new plots, you almost have to go to the Civic Cemetery, and they have various options there for you as well. So having said that, I think that's pretty much my stuff. Does anybody have any questions? Oh, by the way, the best news is some of you are making notes, but Joffrey and I wrote a little booklet, and everything I just said is in the booklet. They're out in the courtyard. Take them when you go home. You can take this to any funeral home or anywhere in Canada. That back page, you can actually, to your point, Chantel, there you can prearrange your funeral in your own house, mail it in, and people know what you want. Yes.
In Sudbury, we're seeing a huge increase in immigrants coming to live in our community of Sudbury. Do you have any advice based on your experience about ways that immigrants specifically can prepare? Because we notice that a big push for GoFundMe's when people die. Some of them want to go back home. Does your funeral home cater for that kind of conversation about people wanting to be shipped back home, back to their home countries when they die?
Good question. Yes, the short answer is yes. This past year, we have sent 2 people back to Nigeria. We've often sent people back to Europe, and we actually have sent 1 person back to Finland. So again, we can make the necessary travel arrangements. That's not as easy as just saying, I want to go home, because the Canadian government basically has regulations with regard to allowing you out of the country, and the receiving country has basically lots of rules and regulations of how they'll receive you. So in fact, even the preparation of the body, how the body is shipped, and if there's diseases in your country. COVID basically brought a standstill to all of that, but prior to COVID. But you ask a really good question, which is one of my pet peeves. GoFundMe campaigns, all right? And I see them in the paper, and I'm serving those people. Now, these aren't the people going home. These are people having funerals in Sudbury. What did I tell you about 20 minutes ago was that nobody can be made to pay for somebody else's funeral. So I know that some of the GoFundMes I've seen in the paper, I know ODSP has already approved that funeral. They're having a visiting, they're using my chapel, they're going to a church, they're being cremated with no cost to the family. So sometimes I'm a little jaundiced with regard to the GoFundMe. If the GoFundMe, and we just had a person going back to India, was one of the accidents, and that person needed the GoFundMe money. If you're going with the person that went to Nigeria was about $13,000. The person that went to India was about $16,000. But that's including airfare, both countries, the consulate fees, the casket, the embalming, etc. So yes, we are an advocate for that. Perhaps more importantly, we also know the rules and regulations to the outing of Canada and the receiving from the other country. Also, it's kind of same church, different pew in a literal sense, also different faith traditions. So we're obviously in a faith tradition that we practice right now. But for example, we buried Mr. Spiegel last week, who was one of the leaders in the Jewish community. And so that they have a Jewish burial committee, and we actually have a special room for the Jewish burial committee to come, and they have a special shroud that they use. People of the Hindu faith do not go to the funeral home at all. They go directly to the crematorium, and they have the Hindu prayers in the crematorium. The oldest son pushes the button for the symbolic flame to actually start the cremation. Muslim funeral that we just recently had last month, they have the imam come over from the mosque, and they meet at the cemetery and have that. We're kind of pleased with what we just did last month. So in remodeling the funeral home last month, I actually built a cedar bathroom. So we started last month with our own cedar bathroom for the indigenous people, and that they have a cedar bath. They also have their smudging. They have different rituals they do to the body preparation with the moccasins, etc. And now they have their own dedicated space. So back to your multicultural question, the funeral provider needs to be sensitive to that. Other questions?
Well, we're just getting ready to wrap up. I have some from online as well, but before we do that, I really got to say we've got the Einstein of Death on stage here today, don't we? I was going to say Lord of Death, but I didn't want to go there. But Jerry, thank you and thank you guys for all of your very good advice. Yeah, it was just absolutely excellent today, and I know that you've gotten a lot out of it. So I do want to speak right now to Ian. Maybe if you can make your way up here so that they can hear. And Jerry as well, please. Yeah, there's another question here for you as well. So here's a question, and it's this. Can a will and power of attorney be updated by simply changing it in ink and initialing, or does it have to be done by a lawyer? So I'm assuming they've got one already, and they just want to make a change, I guess, themselves. But.
Yeah, so the simple answer with if you have a will that you had executed earlier and you want to make some amendments is you can scratch out and put in the new wording that you might be wanting if you're trying to replace who you might have named as an executor, or you want to scratch out a beneficiary. For those types of edits to be valid, the person who's signing the will has to initial the change. Usually you scratch it out, you initial a change, and then you need 2 witnesses to also, initial where the change is. The concern is that if you don't do it properly and it's not properly executed, then a mistake will be made and it could be challenged if the person were to pass, a certain executor or beneficiaries might challenge it, especially if one beneficiary got removed. And so it is better that if you are thinking of making an amendment to the will, that you would go see the lawyer who prepared it, and that the change is made properly. Just because if you think you're doing it right, chances are if you don't do this stuff regularly, you might wind up making a mistake. And to some of the points that have been made earlier tonight, it's just going to be a problem for the beneficiaries and the family down the road. So if you really want it done right, you should go back. I would recommend going back to the lawyer.
Now, it's interesting you say that because right now in the news, there is a contesting of Elvis's will by his
Priscilla Presley
Priscilla
and the
and the
granddaughter,
granddaughter, right?
yeah.
And so, and that speaks very much to what you just said, right? So,
Yeah.
yeah. Okay, so there's another question here, and that's what's the current cost of a will and current cost of doing a power of attorney?
Well, I can't speak for every law firm in town. I don't know what everyone else is charging per se, but to a certain extent, it depends how much time might be spent preparing the stuff. But I'd say probably the going rates maybe between 500 and 900, depending on how much work goes in.
Per the will and the power of attorney, is that all together?
Well, that would be like a husband and wife.
Okay.
That's sort of. I think that's a fair comment. But if it's more complicated or it's more time, it could be over $1,000.
Okay, great. I think that's it for our lawyer question. And then Jerry, or maybe not, just hold on a second. So we've got, can somebody speak to living wills?
Yeah, the concept of a living will, I think it's an American concept. It's not really a Canadian concept per se. I think it normally means the power of attorney. And so I talked earlier about the powers of attorney. So it's really giving it's while you're alive, but you're giving instructions to other people or authority to make decisions. So normally the concept of living will in Ontario is the powers of attorney.
Also, we pioneered in Ontario, and the Americans had this living will thing, but we developed back in, I was one of the authors to it in about 1988, and it was called the Do Not Resuscitate, the DNR. So a living will often said, and by the way, do no heroic measures for me. If I'm going to die, let me die, which was fine, but the document held no power. So you could write all that you want. But a DNR is from a doctor. Any of you that have a family member at home that is dying, and when you call me and say, I want to prearrange the funeral, what do I need? The first question I ask you is, do you have a DNR for that person? Because if you don't have a DNR and they die, the entire circus shows up, all right? The police show up, EMS shows up, the fire trucks now show up, and they're all in your driveway. And you say, yeah, but my dad had cancer for the last 3 months. Everybody knew he was going to die, but you didn't get a DNR. And any doctor will give you a DNR. They're easy to get. And that is what we have in Ontario, supplementing the living will concept, because DNRs mean that the Bayshore nurse comes in, because doctors are very seldom show up, the Bayshore nurse comes in and says, yes, your dad died of cancer. You now can call the funeral home. We go directly. There's no sirens. There's nobody in uniforms. There's nobody carrying guns and tasers sitting at your kitchen table, because they have to do their job to make sure that person was not murdered. And the whole issue when the DNR started back in 1988, the question was, well, you know, if you didn't like your dad very much and you got a DNR, would you put a pillow over his head and kill him? And what was going to happen with that? To my knowledge, there's been no pillow deaths since 1988, and we've saved a lot of police cruisers and firemen and ambulances showing up at your house. So at the hospice, everybody has a DNR, and if you have the shared care team, which is the hospice at home, they get you a DNR.
Yeah, then just further to that, there's a lot of concepts out there that people see on TV. It's probably more today with the internet, and different countries have different rules with respect to estate administration. And we talked earlier about the death tax. Well, that exists in the U.S. It doesn't exist here, but because of all the media and reading stuff on the internet, like there sometimes tends to be a bit of a confusion, or you wonder if it's here in Canada as opposed to what's in the States. So there's lots of examples of that, and it's probably more prevalent today, like with Facebook and all the social media.
Any questions?
And then another question was if you could speak to organ donation.
So organ donation. please sign up. Another myth is it's not on your driver's license. So don't tell me that I signed my driver's license. Well, then you signed it like 20 years ago, because guess what? That's not how you make donations. It's www.beadonor.ca, I think it is. And you go online and you register. And they can use your body. If you wanted me to get on a hobby horse here, Pastor Sean, I cremate so many healthy kidneys and livers and hearts for no particular reason. I'm a huge advocate that it should be like negative billing. In other words, you should have to carry a card that says, I don't want to be an organ donor, so they won't. Orthodox Jewish people, Orthodox Muslim people, I know there are people who are against organ donation, and I respect that faith tradition, but for the majority of people, we can use, and by the way, they have to do it when you're alive. So this is a situation, and there's a really, and we're being live streamed, so I'm sure we likely have some nurse that's going to call tomorrow morning and say that was kind of brutal. But in the Emerge, when they rush you into the Emerge, they'll ask your family, are you agreeable, Andrew, to that being a donor? And if you say no, they said, oh, we're not going to do it. So you really have to make it adamant with your family. I signed to be a donor, and I want to be a donor. And even if they find you dead, for 6 to 8 hours after you're dead, they can still take your cornea. I was the chair of the eye bank for Northern Ontario, and they can always use your cornea. They're either going to use it for transplant or they'll use it for research. They never, ever throw a cornea away. But beyond that, they can use bones now, they can use skin now, and they can use the organs. But you gotta sign up on that website, and then you will be registered, and when they put your name in, Trillium will say, absolutely, Ian Davidson is that person. And you know what? I celebrated my 60th birthday almost 9 years ago, and so I hate gifts. That George Carlin thing for us older people in the audience, that, I need no more stuff in my life. So I asked all my friends, and I asked my churches, and I asked everybody to sign up. And that month, and I think Ian, you and Kathy marched along with the Irish Heritage Club, 627 people who got signed up that week. It costs nothing, and it sure can save lives. So please, please, please do that. And by the way, there's nothing anti-Christian or faith about that. Given your organs, God created all our parts. And if you can share a part, God bless you.
Excellent. And I've got one well, it's not personal, but it was a curiosity of mine. And I'll paint a scenario, and maybe you could speak to this, maybe Jerry as well here. So if say I've got elderly parents, and they've got a will, and in the will, they decided that their assets are going to be split evenly among all of the kids. And say that right now, we'll say me, if I passed away, what would happen then to my family if with those assets at all? My wife, my grandchildren, their grandchildren, sorry, my own children, but their grandchildren.
Well, the simple answer to that is it really depends how the will's worded, your parents' will's worded. If the will is worded in a way that, I think I talked about this briefly, but if your parents' will is worded that if you were to, any one of their kids, which would be you, were to pass away, then it would go, to your estate. So that's how it would pick up. But if their will sort of reads that it's to be divided amongst my kids, or my kids that are living when I pass away, then your parents get excluded. So when we talked earlier about how often should you be looking at your will, well, about every 10 years, because circumstances should change. So, but this is a case where, the details count, like, specific wording counts, and, this is where, you can have problems. The beneficiaries might challenge the will later.
1 minute after 9, we're pretty punctual, so we did a good job with that. Thank you all very much for coming tonight. The questions will be out in the lobby. Thank you.
Thanks online for joining us. God bless.